Good evening, everyone. I'm Ankit, and you're watching the Indian Express analysis, which goes live every day at 4 p.m. on StudyIQ IS English channel. Now, today is 25th of March, and we are going to discuss important news and articles from today's The Indian Express newspaper. And as you can see, the first article of the day is about the very controversial Waqf Amendment Bill of 2024. Now, this bill was earlier introduced in the Parliament of India, but as there were many controversies, so this bill was referred to a joint parliamentary committee to suggest some kind of amendments and improvement. So we're going to understand what are the controversial provisions in this particular bill and also what are the suggestions that have been given by JPC or a joint parliamentary committee to make certain kind of changes in this kind of a bill. Now this bill deals with the matters of administration of Waqf properties. What are those properties? We're going to understand today, and as this is a legislation, therefore it becomes relevant from GS paper 2 perspective, that is polity and governance syllabus. Understood? Then we'll understand in the second article, we'll understand what is judiciary's in-house method of conducting an inquiry against any allegation made on a particular judge. And this article is in news because an severe allegation was made on a judge from the Delhi High Court of hoarding a large amount of cash, which was discovered after his house was burnt due to some kind of a fire incident. Now, we have seen that the Supreme Court Collegium has transferred that particular judge back to his parent High Court, that is the Allahabad High Court. But we'll try to see what are the processes in which judiciary and its internal mechanism deals with certain allegations against those judges. So this again deals with the judiciary, which is relevant from the GS paper 2 perspective, right? So therefore, this is again a polity related development. Then in the third article, we'll understand India's move as India is considering to abolish its equalization levy. Now, equalization levy, in other words, is also known as Google tax. So what is this Google tax? How is it different from other kind of taxes like corporate tax or income tax? We'll try to understand in our today's discussion. And as it deals with the matters related to taxation and fiscal policy, hence it is a part of GS paper 3 syllabus. As you can see in GS paper 3 syllabus, there is a heading called as mobilization of resources, and also this is a part of government budgeting, so also relevant from GS paper 3 perspective. Then in the fourth article, we'll understand what is merchant discount rate. Now merchant discount rate has been in news recently because Government of India announce certain kind of incentives so as to promote UPI in India, particularly for small businesses. Now, in general, from the implementation of demonetization and onwards, we have seen that the government is trying to promote digitization in payment system, and one of the method that government used to promote digitization was to waive off the merchant discount rate. So we'll try to understand what is this merchant discount rate, how it actually helps in promotion of the digitization of payment services, all of this which is relevant from GS paper 3, that is the payment and settlement system. We'll be understanding this particular development, and in the end we'll be trying to understand the political and social philosophy of a very famous politician in India who existed back in India, that was Dr. Ram Manohar Lohia. And why we are going to discuss, because there is an op-ed in today's newspaper written by Yogendra Yadav highlighting the achievements of Dr. Ram Manohar Lohia. Now, although Dr. Ram Manohar Lohia is not present with us anymore, but we understand his political philosophies has been quite popular, particularly in the states of Uttar Pradesh and Bihar, where even the political parties that exist today, they actually tell that the Ram Manohar Lohia were actually their political guru. So we'll try to understand what were his political philosophy, how it compared and contrasted with the ones that were existing back in his time, most primarily being the Mahatma Gandhi. And also we'll try to solve a question, because in 2020 a question directly appeared on comparison of political philosophy between Mahatma Gandhi and Karl Marx. So similarly a question can also appear on Dr. Ram Manohar Lohia. Understood? So that is why these are the 5 articles that we are going to discuss today. Yashi, Lydia, Swastik, Shushmita, Augustine, Baga, SS Talks, Neha, Arya, Gaurav, good evening all of you. Now, the notes for this session as usual will be available on my Telegram channel. The Telegram channel is called as ATS Live. So you either have an option to type and search ATS Live on your search bar located on the right top hand corner of your mobile app, or also you can scan this QR code which will take you directly to my Telegram channel, right? And before dealing with our today's discussion, let us try to solve the yesterday's homework that I gave you. This was a very similar question to the PYQ which appeared in the prelims in 2020. That question asked you what does Western Texas or Western Texas intermediary deals with, right? Or what Western Texas intermediate is. Similarly, I've curated a question on Urals as we have discussed yesterday. Ural is a medium sour grade of crude which is available from Russia. Therefore, it is a grade of crude oil similar to WTI, similar to Super Arabic, etc. Understood? Yes, Shushmita, Baga, Lydia, Gaurav, Sarang, all of you are correct. Swastik, yes. Now you should have given this answer in the comment section of yesterday's video, right? Rather than waiting for me to solve this question, I saw there was no comment. Why do you do such thing? So if you do, please make sure to like this video and also let me know in the comments whether this session is helpful for you or not in regards to the UPSC preparation. Okay, so let us start our today's discussion with this first article, and this appeared in the explain section of the Indian Express newspaper, which today is on page the 16th. Now this article deals with the controversial or contentious provisions that are there in the Waqf Amendment Bill of the 2014. Now this Waqf Amendment Bill of 2014 has elicited huge widespread criticism all across India, as a famous Muslim body known as All India Muslim Personal Law Board on Sunday it has announced that it will conduct a nationwide agitation against the provisions of this bill. Similarly, a Bihar-based Muslim organization known as Imarat-e-Sharia, it has announced that it will boycott the annual iftar ceremony of the Chief Minister of Bihar, that is Mr. Nitish Kumar. Similarly, the Indian National Congress has called the bill as an assault on the constitution and an attempt by the ruling party, that is BJP, to keep the society of state in a permanent polarization for its electoral gains. So this kind of a political statement is not relevant from our news article. What is in fact relevant is what is the Waqf property, how is it regulated, what are the key provisions in the Waqf Amendment Bill. So we'll understand in our today's discussion all of these things. Now first let us understand the meaning of the word Waqf. Now Waqf, it refers to the properties that have been dedicated exclusively to be used for religious or charitable purposes under Islamic law or any other use or sale, and the use of this property except for religious and charitable purposes is prohibited. Similarly, you can't sell this property in open market because it is prohibited by law. Now, once a property is given for religious and charitable purposes under the Islamic Act, it becomes a Waqf property, and the ownership of this property is transferred from a private individual who might be owning the land beforehand, and the property now is vested in the name of the God, that is Allah, therefore making this process irrevocable. Now as Waqf properties, they are bestowed upon Allah, so in his tangible and physical absence there is a person who is nominated to manage this kind of a property, and this person is known as Muttawali, who is appointed to manage and administer the Waqf properties. Understood? Now in general, the objective of this Waqf Amendment Bill is to amend the existing Waqf Act of 1995, and this act, it actually provides for different kind of a state-based Waqf boards who are responsible for managing the Waqf properties in a particular state. Now the Amendment Bill, it tries to amend this particular act to readdress the issue and challenges that is present in regulating of present Waqf properties, and this Amendment Bill, it seeks to improve the administration and management of Waqf property in India, and it aims to overcome the shortcomings of this Waqf Act 1995 of the previous act to enhance the efficiency of state-based Waqf board by updating the definitions of what makes a property Waqf property, improving the registration process of this property, and increasing the role of technology in managing the Waqf board. Now right now there is no mandated registration for any property known as Waqf property. So we see there is a increased amount of dispute, that there are many more than one claimants to a particular property, one of which is state-based Waqf board. So in order to reduce these kind of disputes related to Waqf property, now this bill mandates the registration of such kind of a property in a portal passed by the government. Now in this regard, let us try to understand what are the provisions in this amendment bill which makes this amendment bill contentious or controversial in nature. First of all, you have to understand that this 2024 bill, it proposed allowing non-Muslims as a member of this Waqf board. It includes a non-Muslim chief executive officer and at least 2 non-Muslim members to be appointed by the state government in their respective Waqf board. Now this is a very controversial provision because earlier the Waqf board, it constituted people solely belonging to the Muslim religion, but now with this amendment, if this is passed by the parliament, now even non-Muslims can be the member of state-based Waqf board. Now to deal with certain kind of controversy, the Joint Parliamentary Committee, after which the bill was referred to this particular committee to make certain kind of changes, this committee allowed 2 amendments to this particular provision. This committee actually recommended that the appointee shall be an officer of joint secretary level or higher in the state government, and also he or she shall have the knowledge of Muslim law and jurisprudence. But even this committee has not recommended the fundamental matter of the controversy related to this provision, that is inclusion of non-Muslim members into the Waqf board, given that this Waqf board is exclusively managing the religious based property. So the people belonging to Islamic religion, they want that only people belonging to Muslim religion should be represented in the Waqf board. So this contentious provision still remains. Now the next contentious provision is the power of the government. Now 2024 bill, it gave the power to consider or determine the disputed property, whether it belongs to Waqf board or government. This will be determined according to the bill by the district collector of a particular district. Now earlier this matter was referred to Waqf tribunal. Now the power of determining whether this property belongs to Waqf property or is it a government property, this will be decided by district collector and not Waqf tribunal. Now Joint Parliamentary Committee accepted an amendment to this provision which now gives the power to a state government officer who is senior or even more senior than the district collector. However, it's still the people from Islamic religion are highlighting that although there is a chance that government will also be a party to the dispute, whether or not that particular property belongs to the state government or it belongs to the Waqf board. So when state government will be a party in this dispute, how can you nominate an officer of the state government to deal with this kind of a dispute? Naturally, if an officer of the state government will decide on this matter, there is a chance that the officer of the state government will decide in favor of state government, right? So this belongs what is called as conflict of interest. Okay, so therefore this is a contiguous or contentious provision, that it still will be a state government officer who will adjudicate whether this property belongs to Waqf board or state government, and critics fear that officer is more in favor of, likely to rule in favor of the state government and not in favor of Waqf board. Understood? Now there is another contentious provision, that is removal of the parameter known as Waqf by user. Now the 2024 bill, when it was introduced, it did away with the concept of Waqf by user which was present actually in the 1995 law. What is this Waqf by user provision? Now if any property, it was treated as Waqf property if it was for a long period of time used for religious and charitable purposes, irrespective of the fact whether there is a legal property or legal process that have been completed to hand it over to the Waqf board. So if a property, despite not having a significant documentation, even if that property was used for a long time for charitable and religious purposes, that property was called as a Waqf property. Okay, so this was what Waqf by user means. Now by omitting this provision of Waqf by user, this actually will lead to significant amount of dispute in many properties who do not have a valid Waqfnama, that is a legal document highlighting that this property now belongs to Waqf. Whether or not it was used for a long time now does not matter by the law, because it did away with the concept of Waqf by user. Understood? Now good evening Saujanya, good evening Rishav. Another contentious provision is the Waqf database. Now 2024 bill, I told you, it mandated that every Waqf property will be registered on a central database within 6 months of the law's commencement. Now any government property, if it were to be registered as Waqf, naturally it will be highlighted to the government and then it will allow the government to conduct an inquiry whether this property actually belongs to Waqf or the state government, and this will be inquired to by the district collector. Now this bill ensures that not registering any property on the portal will actually mean that the Waqf is actually forfeiting the right to move through court in case of any encroachment or any dispute happens to this Waqf land. So in case Waqf board does not register any property on the portal, that means they will waive off the right to hear this matter in this court, and the JPC has accepted certain amendments to this bill, giving that the Waqf tribunal will now have the power to extend the time frame for registration in some circumstances. But what is contentious that it is upon the discretion of the Waqf tribunal to highlight what are the circumstances under which the registration date will be elongated. Understood? So these are the problems that is associated with this kind of a amendment bill. Also, the decision of the tribunal. Now earlier, whether any dispute was regarding to the Waqf Act, it was referred to the Waqf tribunal, and the decision that the Waqf tribunal gave was full and final. Now the amendment bill has changed how the Waqf tribunal will be formed. Now it will comprise of a district judge, a state government officer of joint secretary rank as its members, and another crucial change is that the new bill, it will remove the provision that made Waqf tribunal decision as the final decision. Now what will happen, that in case of a Waqf tribunal decision, and if you do not agree with it, you can challenge the Waqf tribunal decision in the High Court. Understood? So therefore, these are the provisions that have diluted the powers of Waqf tribunal. It has diluted, or it has increased the power of state government over whether to decide which kind of a property is Waqf property or not. Therefore, this has become a contentious issue. Now this development is ongoing. Whether or when this bill will be finally passed in the parliament and it will become an act, rest assured I will cover in great detail about each and every provisions of this article in our discussion. Okay, so this is what is relevant from your perspective as far as today's news is concerned. Now let us move to this next article. Sir, I did not understand the right to move court line. Please explain again. I hope you are expanding upon right to move this, right? That suppose if you have not registered any particular Waqf property under the portal passed by the central government, then in case any dispute happens in the future, you do not have the right to move to court because that property first of all is not registered by the government. So technically there is a property related dispute that can happen with a private property, with a commercial property, with a Waqf property. So what is your recourse that you have in? You can go to court highlighting that, see, this is the document, I own this property, so any person who is claiming this property should be barred from claiming my property. So this is how you move to court. But when you will not register this Waqf property in the court, this means you will not have, or the Waqf board will not have the right to move to court in case any future dispute happens with this property. Understood? Hope I made everything clear, Sejal. Now let us move to this particular article which also appeared in the explained section, that is on page 16 today, and it states about judiciary's in-house inquiry process. And why we are hearing about this inquiry process, because Chief Justice of India Mr. Sanjeev Khanna has actually initiated an unprecedented 3-member in-house inquiry against the allegations of conduct of a Delhi High Court Justice Yashwant Verma, following several allegations that was made on him that several or huge values of currency notes were found in his official residence when the fire broke out in his residence on March the 14th. Now this internal inquiry of the judiciary, it is a very different process as compared to the impeachment or the removal of such judges which is given in the Indian Constitution. So in this regard, let us first understand how a judge of the High Court or Supreme Court for that matter can be removed from office, and how the internal inquiry process of the judiciary is different from it, right? So first let us understand the removal process. Now the removal process of the judge of Supreme Court is given in article 124 subsection 4. Similarly for that of High Court judge, it is given in article 218. Now for both of them the ground of removal is same, that they are removed in two cases. First is proved misbehavior and second is incapacity. And how they are removed, that a resolution is first introduced in the parliament and that has to be passed by the parliament with a special majority, that is majority of total membership and majority of not less than 2/3 of members present and voting. Now suppose there are 245 members in the Rajya Sabha of India, right? So what does this two means majority of total membership, that is more than 50% of total membership, that is at least 123 members should be there, and not less than 2/3 present and voting. So in case there are 100 members at a day present in Rajya Sabha. Now what is 2/3 present and voting? This is 67 members. So do you think 67 members, when they vote in favor of removal of a judge, will they be removed? The answer is no, because it is less than the total or majority of total membership of the house. So both of these conditions have to be satisfied simultaneously, then only a judge can be removed from the house. So suppose 200 members are present in a Rajya Sabha in a very particular day in which the voting process will happen. Now what is the 2/3 of this? This is at least 134 or 135 members, right? So suppose if 136 members decide to vote against or for removal of this particular judge, it is more than 123, which is majority of total membership. So in that case, the judge will be removed from office as the judge of a particular High Court or Supreme Court. So this is how the removal process is completed, that is voting by the House, and this voting requires a special majority, that is majority of the total membership, that is more than 50% of the strength of the particular house, and majority of not less than 2/3 members present and voting. Understood? And this process is not just it. First of all, the process of removal is given in the Judges Inquiry Act of 1968, and it states first the motion of impeachment has to be introduced in the floor of the House, and if introducing in the Lok Sabha, you require not less than 100 members to sign that particular motion, and if it is required or introduced in the Rajya Sabha, you require permission of at least 50 members before you introduce this motion of impeachment in the House. Now, once the motion of impeachment is accepted by the presiding officer of the House, then a 3-member committee of inquiry is formed to consider this motion, and it consists of Chief Justice of India or a senior judge of Supreme Court, Chief Justice of any High Court, and a distinguished jurist who is appointed by the Chief Justice of India. And these 3 people actually investigate the charges, and in case they highlight that this allegation is actually true, they will frame the charges and also seek medical tests in cases of allegation against incapacity. So all of this process is done by this 3-member committee of inquiry. Now, once this committee of inquiry actually concludes the investigation, they will file this report to the presiding officer of the House, that in case of Lok Sabha, it will be given to the Speaker of Lok Sabha, and in cases of Rajya Sabha, it will be given to the Chairman of Rajya Sabha. Now, this report will be placed on the floor of the House, and if the report says that that judge is not guilty, then the matter ends itself. However, if this report says that the judge is indeed guilty, then in that case, report is adopted in the House, and this voting process that I told you in the last discussion, this voting process will happen. Okay, so this is how the judge is indeed removed from the office through this process, which is given in both Constitution of India and as per the Judges Inquiry Act 1968. Now, in total, there have been 6 attempts till date to remove a judge from the office. However, there is no judge in the history of India who has been removed from office through this process. And in this 6 attempts, actually 2 instances we have found that these judges were actually guilty of proven misbehavior or incapacity, and even then they were not removed from office. You can understand this process is filled with huge hurdles, especially the procedural hurdles, which makes this removal process quite difficult. So in that case, the Supreme Court actually considered that there are many cases where the complaint is made against certain kind of impropriety by the judge. So what happens in case certain complaint is made, and for that an in-house procedure has been adopted by the Supreme Court. Now, it is not necessary that a complaint against a judge is made or it is made only to the parliamentarians. Even the judiciary itself can consider whether the complaint is true or not, and what kind of action should be taken against a particular judge in case that allegation is true. Now, the Chief Justice of India, or for that matter any High Court, may be called upon to examine such complaint against a judge. And in a previous case known as C. Ravichandran Iyer versus Justice A.M. Bhattacharjee case, where an allegation was made against a Bombay High Court judge, Justice A.M. Bhattacharjee, by the Bar Council of Maharashtra, and it actually led to a dispute in Supreme Court, and Supreme Court considered that there is actually a gap between bad behavior by the judges and a behavior which is worthy of impeachable or removal of judge from from this office. So in that case, judge is actually responsible for a bad behavior, but it is not as bad to be considered for its removal from office. So in that case, judiciary does not have an option to punish the judges. So for that, there is a need for a process that should actually hold the justices accountable for their conduct, and therefore to hold judges accountable for bad conduct which is inconsistent with the high office of justices. However, when such conduct did not meet the high bar for impeachment, you need certain kind of a process that should hold the judiciary and the justices accountable. So in that case, a separate in-house mechanism was derived. Now this process actually begins when a complaint is received by Chief Justice of a High Court, Chief Justice of India or the President of India, and the Chief Justice of High Court or the President, if they have received the complaint, they will forward this complaint to the Chief Justice of India. Now this complaint can be dropped if the allegations are not found true by the Chief Justice of India. However, the Chief Justice of India usually refers this matter, or to test the actual veracity of the complaint, Chief Justice seeks a preliminary report from the Chief Justice of a particular High Court where the matter has actually originated. Now, if the Chief Justice of High Court actually in his preliminary report recommends that actually a deeper probe is needed for the matter, then in that case CJI may examine the recommendation and actually state for formation of a committee, which is a 3-member inquiry committee which will consist of 2 other High Court Chief Justices and 1 High Court judge. Now this committee, when it will be actually investigating the allegations against a particular judge, they will have the power to decide their own procedure, and naturally they follow the principles of natural justice, that they consider all the evidences that are there and even call the particular judges against whom the charges has been levied to explain his or her stance in front of them. Understood? So this is how this committee conducts inquiry. Now once the inquiry of this committee is concluded, the committee will submit its report to the Chief Justice of India, and this report might state that actually there is actually a substance to the allegation against the concerned judge, and if there is a sufficient substance against the particular judge, whether these are serious enough for removal of that judge from office or these are just enough to be considered as a disciplinary action. Now if the committee concludes that the misconduct is not serious enough to be warranted removal from office, then in that case CJI may advise the judge in some ways or even direct the committee of the report should be placed in public record. And in case if the committee recommends that this judge actually was responsible for proved misbehavior or incapacity, and if this committee recommends removal proceedings, then in that case CJI will advise the concerned judge to either resign or retire voluntarily. And if the judge does not accept the recommendations of the CJI, then the CJI will direct the High Court Chief Justice to not assign any judicial work to that particular judge. And if the judge still does not abide by the CJI's advice to resign or retire, then the CJI will inform President and the Prime Minister of India to actually start the removal proceedings in the Parliament. And what are the removal proceedings? I have already told you that a motion is introduced in the House, and after the motion is introduced in the House, a separate committee of inquiries constituted, and according to the report of this committee of inquiry, a voting process happens in the both of the houses. That is, it requires special majority to remove a judge from the office. Understood this entire in-house procedure? Now let's see if you can solve this particular question. With reference to impeachment of judges in India, consider the following statement. A judge of Supreme Court or High Court can be removed from office by the President only on the grounds of corruption. Now what did I tell you on the grounds of removal? There are 2 grounds: proved misbehavior and incapacity. Okay. So corruption is not one of the grounds, therefore first statement becomes incorrect. The second statement, the process of impeachment requires simple majority of the membership of both houses of the Parliament. Now it requires a majority of total membership of the house and more than 2/3 present and voting. Understood? So this is called as special majority and not simple majority. So second statement also becomes incorrect. And the third statement, the detailed procedure for the impeachment of judges is governed by Judges Inquiry Act 1968 in addition to the provisions of the Constitution. Third statement is a straightforward one and a correct statement. So 1 and 2 is correct. Third one is 1 and 2 is incorrect. Sorry. Third is incorrect. Third is correct, and we have to identify correct one. So option B here is the right answer. SS Talk, Shushmita, Madison, Sejal, Lydia, Baga, Sarang, all of you are correct. Sir, can you suggest any good book for political philosophy which would enhance knowledge and will serve also purpose of reading habit, which in turn can solve reading comprehensions easily? Well, Bishwabrat, if you don't have political science as your optional, I wouldn't recommend you to read any book on political philosophy. Only if it serves your academic purpose, then only you should read such book right now when you're preparing for civil services. Otherwise, there is too much material for you to read. Read those material that you should use to qualify the exams. Okay, Vishwabrat. Now, these matters which detailed or which is related to how judiciary functions and what are the related constitutional provisions, these are dealt with effectively in our polity classes. Now, not just polity, but all the subjects, that is economy, science and tech, environment, geography, history, everything, it is dealt in much detailed manner in the Sampoorn batches. Now, what are Sampoorn batches? These are also known as P2I batches, where we cover everything which is relevant from prelims to mains to interview, and these batches ongoing, the March morning batches, the admissions are ongoing right now, which will close on 31st of March. Now, if you want to enroll yourself for these March related batches for StudyIQ IAS, what you need to do is create an account on StudyIQ website. So you can create an account here, and to enroll for such courses, you have to click Explore Courses. Now, once you click Explore Courses, you can see that the admissions are closing for March morning batch. Admissions will be closing on 31st of March. And to enroll for courses, particularly the courses which are offered exclusively in English language, what you need to do is click on this UPSC IAS English here. And as soon as you click, there is admission ongoing for P2I Foundation 2026 March morning batch. Click on this tile, and as you can see, the course right now is offered at 37,499 rupees. But using the ticker that is flashing on the bottom half of your screen, you can still get more discounts on even on this amount. Now click on buy now. Now you will be asked to add a promo code here. Click on add promo code, and as soon as you enter coupon code, write ATS live. Now, as soon as you write ATS live, click on apply, and as you can see, when you click on apply, the ATS live code is live, and here the discount available is for 7,499. So technically the course fees has reduced from 37,499 to 29,999. So that this is how you register for courses, and please make sure to use the code ATS live if you want to get discount. Understood? Now, moving back to our discussion, let us now move to the next article of the day. This article appeared in the business page of the Indian Express newspaper today, which is on page 15, and it states that the government is proposing to abolish 6% Google tax amid the US tariff pressure. Now, the government has proposed in its dealings with the US government to abolish the equalization levy on online advertisement, which is now a part of amendment to the financial bill of 2025, in a move which experts deem as a signal that India wants to remove some taxes on the businesses and make the conditions in India more conducive for businesses, particularly American businesses. Now, government earlier had already removed the equalization levy that it levied on e-commerce companies last year. Now, this removal deals with the online advertisement. So, in our today's discussion, what becomes relevant is what in the name of God is this equalization levy that most of you must have heard income tax, most of you must have heard of GST. So how is equalization levy different from income tax, GST or other forms of taxes? Let us understand this in our today's discussion. Now, before understanding this, let us take a very brief background on this issue. Now, before 2016, what used to happen that only those companies who were registered in India and had a permanent presence in India and physical presence in India, they were required to pay taxes on the income that they get in India, and this was a part of Income Tax Act 1961. Now, this is because you have to understand these companies who used to earn from businesses or their business related activity in India, and first of all they had to register their businesses in India, they had to open an office, and then they had a physical presence in India, and only then these companies were able to do businesses in India, and this was the time when online businesses were not that prominent. But after 2016, what we saw that the advent of information technology happened. So we saw that companies like Google, who offered their advertising services to companies in India, they did not have a significant physical presence in India. So technically companies like Google, they were registered in US and had a permanent resident status not in India but in countries like US, but the source of their revenue is through selling of online advertisement companies to companies located in India. So this actually made them not liable to pay income tax, or they are not liable to pay income tax under the provisions of Income Tax Act 1961, because Income Tax Act actually required a company to have their physical presence in India, but we understood such big IT companies, they can offer their services digitally, or even having a presence in US, they can offer services to companies in India. So how will actually government be liable to tax certain kind of companies who did not have a physical presence in India? So in that case, government came up with the idea to levy them with the equalization levy on their income from India, and this is also alternatively called as Google Act. So equalization levy is also known as a Google tax, which was levied from 2016 onwards to companies who did not have physical presence in India, but they were offering many kind of services to Indian based companies, be it e-commerce services, be it online advertising, etc. So let us understand what is the legal status of equalization levy. Now equalization levy is not under the income tax law, as it is a tax on income. Rather, it is an independent levy which was introduced through Finance Act of 2016. Now technically there are two kinds of services that qualify to be charged under equalization levy. These are sale of digital services like advertisement, and also from April 2020 onwards we saw 2% of equalization levy was applicable on e-commerce firms who are operating from outside the India. Now this on equalization levy on digital ads were 6%, whereas on e-commerce this was 2%. Understood? Now technically you should understand how this equalization levy works. Suppose this is a company A which is based in US. Now if this company A sells goods and services to consumers in India, right, without having a significant Indian presence, so that company will be required to pay equalization levy. Or suppose if company A forms a subsidiary called as company B in India, and that company B will sell goods and services to consumers in India, that company will be required to pay income tax and not equalization levy. Understood? So this company A, if it is selling goods and services directly to consumers in India without having a physical presence in India, that company will be required to pay equalization levy and not required to pay income tax. Whereas if a company A forms a subsidiary called as company B in India, and if this company B sells goods and services to consumers in India, that company will qualify to pay income tax and not equalization levy. So this is how Google tax or equalization levy works. So technically how this equalization levy works. Now suppose if XYZ is an educational institution in India, and if it wants to promote that this XYZ educational institution in India is ranked 1 in India, unlike IITs, then it will ask companies like Google to do advertisement on its own platform saying that XYZ is a best institute in India. Now, as you can understand, Google is a company, it might not have an online or Indian subsidiary, so therefore Google is a company registered in US. So before paying for the fees of this online advertisement, what XYZ company will do is that it will deduct 6% of the equalization levy on the total revenue that it is required to pay on Google, and this payment will be made to the government as under the equalization levy. Similarly, suppose if you want to order a watch from Amazon US website, and this particular watch is not available on Amazon India website. So technically you buy that watch from Amazon US website and you are required to pay 100 rupees for that watch. So suppose if you are going to transfer that 100 rupees, you have to deduct 2 rupees of that and you have to submit it to the government as form of equalization levy on the e-commerce platforms. Understood? So this is how equalization levy works. It is a direct tax that you need to pay, and you have to deduct this money before paying it to the company, and you have to submit it to the government as a form of equalization levy. Now equalization levy, it is a direct tax and it is levied on revenue and not on profit. And why it is levied on revenue and not on profit? Because it is quite difficult for Indian company to ascertain what profit is Amazon or Google making it from India's selling of goods and services. So it is quite difficult. So that is why, for simplification of this application, equalization levy was made on revenue and not on profit. And now we have understood, earlier on e-commerce transaction this equalization levy was removed. Now even for online advertisement services, the government has said that it will remove this equalization levy altogether. Understood? Good evening, Achal. Now let's see if you can solve this PYQ or not. This PYQ, which appeared in 2018, it actually deals with the equalization levy. Now, with reference to India's decision to levy an equalization levy of 6% on online advertisement services offered by non-resident entities, which of the following statement is or are correct? It is introduced as a part of Income Tax Act, and the non-resident entities that offer advertisement services in India can claim a tax credit in their home country under the double taxation avoidance agreement. So which of the statement is or are correct? Let me know. SS Talk says option C, Sarang says option D. दोनों में से तो एक सही होगा या मे बी ए और बी सही हो. Now this though I told you, this is not under Income Tax Act. This was introduced separately through Finance Act. So therefore first statement is correct. What about second statement? Whether first statement is correct or why is it correct, or if it is incorrect, why is it incorrect? Can anyone let me know quickly? Sarang, Shushmita, why are you saying option D is correct? Now, what is double taxation avoidance agreement? Double taxation avoidance agreement says that two countries who sign these agreements, it is said that a company which is operating in both these countries, they are only required to pay their income taxes in one of these countries. But now, as you can understand, equalization levy is not an income tax. Understood? It is a separate kind of a tax. So technically, when this does not qualify as income tax, how will it qualify to be called as a tax under double taxation avoidance agreement, right? So therefore, first statement to incorrect thai, even second statement becomes incorrect. So therefore, Sarang, Shushmita, Yashi, option D is the right answer, and the reason is equalization levy is not an income tax. So therefore, the companies who are paying equalization levy can't claim it as a benefit in their home country under DTAA. Now let us move to another article. This one article actually says that the Payment Council of India has stated that MDR should actually be levied for RuPay cards and for UPI payments made by large businesses. So in this regard, let us understand the context of this article. Now, the Payments Council of India, which is an industry body representing as much as 180 different members, it has proposed for introduction of merchant discount rate for RuPay based debit cards for all merchants and a reasonable MDR of 0.3% for UPI only for large merchants. Now, saying that this levy of MDR in these transactions will ally with the existing MDR, which is available for many kind of prepaid instruments like non-RuPay based debit cards and also for all kind of credit cards, and therefore companies who are using these credit cards have to pay about 2% of MDR, whereas non-RuPay debit cards, the companies have to pay 0.9% of MDR. So in this discussion, what is important is what is this merchant discount rate. But first, let us understand how this payment process works, right? Suppose this is a shop where you are going to buy a cloth, right? Now you are the consumer, okay? Consumer A. Now if consumer A goes to the shop and buys a shirt, now to pay for that shirt, this consumer A says that I will pay you through a credit card. So the shopkeeper takes out a POS machine to say that please give me your card, I will authenticate the transaction and then you can make this payment through inletting your password. Now suppose this A person has a bank account in the ICICI bank. So naturally his debit card or credit card will belong to ICICI bank. But what about the shopkeeper? It is not necessary that the shopkeeper might have a bank account in the same bank. So technically the shopkeeper may have a bank account in the SBI, So how will the transaction happen from ICICI to the SBI when this person wants to make a payment through debit card or credit card? So for that matter, the companies like Visa, MasterCard, they establish a payment system and they will provide this point of sale device to the shopkeeper and saying that do not worry, you might have an account in SBI and you might receive payment from different kind of customers who might have their account in SDFC, ICICI, PNB or any other bank. I will ensure that the money is debited from their account and it is credited and provided in your SBI account. So use my POS device, and for that or for this utilization of the services, I will charge you certain kind of a commission, and this commission is called as a merchant discount rate. Understood? So this is what MDR is, that a company like Visa, MasterCard, American Express, RuPay, they are giving these POS machines to the shopkeeper, and using these POS machines, the shopkeeper can accept payments from any bank account using debit card and credit card. But in levy of these services, the companies will charge a commission on the transaction, that is some percent of the transaction, and this is known as MDR. Understood what is MDR is? Rishabh Kumar sir, random question. Do alimony will you need to pay taxes? Well, I'm not a CA by qualification. You should ask a CA that question. Do credit cards fall under accrual accounting? Well, actually yes and no. This is a very complex discussion that would require me to explain this to you for 30 minutes. So both yes and no is the answer. Some other time I'll discuss this. So what is actually a merchant discount rate? Now I told you, right, merchant discount rate is a fee charged to merchants for processing these digital transactions, and it is deducted from the transaction amount before the merchant receives the payment. Now this MDR, it is taken by the companies who are providing the offering of the digital payment transactions, and it covers the cost of banks, payment services providers, and even the digital payment platforms. And in other words, it is also known as transaction discount rate. So MDR and TDR, one and only the same thing. Now the question is, who is paying the MDR? Now it is actually the merchants, that is the shopkeeper. They pay MDR for card based and UPI based transactions, but we have understood that is to promote UPI, the government is actually covering the MDI for small transaction in order to promote digital payments. But why is actually government doing this? Because to promote digital payment, right at the time since the demonetization was announced, Government of India has prescribed a zero MDR policy, and this zero MDR policy is applicable for all transactions in the UPI and for transactions that are done through the RuPay based debit card. Now recently, in order to incentivize the small businesses, the Union Cabinet has approved a 1500 crore incentive in order to promote low value Bhim UPI transaction. Now the Payment Council of India, it is saying that 1500 crore rupee which is allocated by the government as an benefit to the payment companies for not charging MDR, it is not an enough amount, because expanding of UPI services and maintaining UPI services, it estimately requires about 10,000 crore rupees on an annual basis. So the allocation of the government, that is 1500 crore rupees, is not enough. And the PCI is saying that sustaining India's digital payments, it would require continuous investments in making innovation, in ensuring that this payment services is provided with cybersecurity benefits, for merchant onboarding, for compliance, and establishing the IT infrastructure. And all of these processes requires a large amount of money, approximately 10,000 crore rupees annually. Now government actually is promoting digital payments, and for that it has ensured that there is no MDR which is levied on UPI and RuPay based debit card, and to compensate the companies, it is offering 1500 crore rupees, which according to PCI is not enough, right? Now the PCI is demanding that the MDR should be applicable on some UPI transactions, that is UPI transaction made by large businesses, and all transactions involving the RuPay based debit card. Now PCI is saying that approximately there are 6 crore merchants in India who accept digital payments, and out of the 6 crore, 90% are categorized as small merchant as per the definition of RBI. The definition of RBI for small merchants is that whose turnover on an annual basis is 20 lakh and below, and out of this 6 crores, 50 lakh merchants are categorized as large enterprises. Now, enabling MDR for rupee-based debit card and UPI for large merchants will ensure a sustainable monetization or sustainable amount of money is received by the payment companies for the banks, and then these companies can actually sustain the digital payments and also ensure that these digital payments are subsidized for the smaller businesses. So that is why PCI is levying that please allow us to levy MDR for certain categories and not the smaller businesses. Understood the rationale behind this move? What is MDR? Now if you have understood what is MDR, let's see if you can solve this PYQ of 2018 or no. So, which of the following best describes the term merchant discount rate, sometimes seen in the news? Please let me know the correct answer quickly. अभी तक एक ही आंसर है और कहाँ है? Anyone else? Only Sarang has given the answer. Anyone else? Yeah, she says option C. Madison says option D. Well, MDR, I told you, right? To facilitate digital payments, the companies are establishing a digital payment network, and they say against this payment network, you are required to give us some kind of a commission on your earning, that is called as MDR. So it is a charge which is levied to a merchant by a bank for accepting payments from his customers through bank's debit card. Option C is the right answer to this question. Yes, all of you, Madison, Sejal, Bagasping, Sarang, Yashi, all of you are correct. Now moving to the last article of the day. This article appeared on page 12 of the Indian Express newspaper, and it is on a very famous political personality in India, that is Dr. Ram Manohar Lohia. Now why we are discussing Dr. Ram Manohar Lohia? Because on March the 23rd, it marked 115th birth anniversary of one of the tallest leaders in 20th century India, that was Dr. Ram Manohar Lohia, and the leaders across political parties, be it Prime Minister Narendra Modi to the former Chief Minister of Uttar Pradesh, that is Mr. Akhilesh Yadav, all of them paid the respects to this leader. So in this regard, what becomes important about life and achievement of the famous personality Dr. Ram Manohar Lohia. Now hailing from Uttar Pradesh, Dr. Lohia completed his higher education in Europe and he returned to India in 1932, and straight away he joined the independence movement as a part of Indian National Congress. But later he critiqued the party and its leader for doing little to dismantle caste and class-based hierarchies, and even many decades after his passing away, he has remained a very politically relevant, and his ideology remains politically relevant because parties have continued to echo his ideas on social justice and describe themselves as a Lohiyas or Lohiyites. So what makes his ideology and what makes his philosophy quite relevant? Let us understand this. Now Lohia, he formed the Congress Socialist Party within the Congress itself in 1933. However, it became an independent party in 1947 known as the Socialist Party, and later iterations of Socialist Party, they have continued to emphasize the philosophy of Dr. Lohia, that was known as democratic socialism. So what is democratic socialism? We understand his philosophy by comparing his philosophy to another famous personality of India, that is Mahatma Gandhi. Now many of the ideas of Dr. Lohia were similar to Mahatma Gandhi. For example, they both were opposed to capitalism. They highlighted that capitalism, which solely ensures to want to make profit, is not a right way to do it. The right way to do it is to distribute the profits among the own people. Also, they promoted the village economy in general. However, the views of Dr. Lohia and Gandhi, they were quite different when it comes to the equation or the question of caste. For one matter, or for that matter, Mahatma Gandhi, he acknowledged the inequalities of the caste system. However, he sought to reform this caste system from within. On the other hand, Dr. Lohia staunchly believed that the entire system has to be dismantled first before making the process of social justice quite easy. So this is where both of their thoughts and ideas diverge, that is on the question of how to deal with the caste system. Now on another hand, Dr. Lohia propounded what was known as Seven Revolution, also known as Sapt Kranti. Okay. Now, his idea of Sapt Kranti, it ensured revolution against gender-based inequality, against political, economic and spiritual inequalities which is based on color of your skin, against inequalities between backward and the advanced group of caste, in favor of special opportunities for backward caste, that is reservation policies. Also, his opposition for foreign-based rule and Western imperialism meant he had a very anti-imperialistic outlook, and because of his anti-imperialistic outlook, he was arrested for more than 25 times even during the freedom movement for India and also during the Goan liberation movement. So he was also anti-imperialistic in nature. Also, while highlighting the similarity with the philosophy of Gandhi, both of them highlighted the importance of non-violence in general. So this is also a similarity in both of their political philosophies. Now, why is actually Lohiya's ideology even currently quite relevant? Now, from late 1960 onwards, the Congress party, it was quite unchallenged when it came to electoral democracy, as Congress party at the time of Jawaharlal Nehru, at the time of Lal Bahadur Shastri, and in the initial years of Indira Gandhi, it went politically unchallenged. But after the death of Jawaharlal Nehru, we saw leadership struggle emerged in Congress. Then who should actually succeed Pandit Jawaharlal Nehru? And this was the time Congress started to become increasingly weaker. That also Congress dominated the central politics, but when it came to regional politics, the dominance of Congress, it started to getting fade away. And this is when the anti-Congress leaders started to getting developed. And veteran socialist leaders like Jai Prakash Narayan, who had many commonalities by Lohiya, they became the two poles who actually formed an anti-Congress leadership. And they made even a call for total revolution, that is Sampoorn Kranti, against the policies of then Prime Minister Mrs. Indira Gandhi. And once, in order to control the large-scale protests that happened under this total revolution, Indira Gandhi implied or imposed emergency in India. Now, because of many excesses done by the government of India during the time of emergency, we saw Indira Gandhi lost her election in the 1977 election. And during the 1977 election, for the first time in independent India, we saw a non-Congress based government was formed, which was formed under the guidance of both of these two leaders, that is Jai Prakash Narayan and Ram Manohar Lohiya. Now, many young leaders who participated in this anti-Congress movement at that time, they were inspired by the likes of Jai Prakash Narayan and Lohiya, and they came from a non-elite political backgrounds. They belonged to caste who were known as OBCs, who were not belonging to the dominant caste at that time. That is, and they emerged in multiple states. For example, Mulayam Singh in state of Uttar Pradesh, Nitish Kumar and Lalu Prasad in the state of Bihar. All of this, they held that JP and Lohiya were their political gurus. Now, in 1990s, we saw government formed a commission to inquire about the possibility of extending reservation for OBCs, and this commission was called as Mandal Commission, and it recommended that indeed reservation for OBCs should be provided in both public education and employment. And this made politicians even more keenly aware of the ideas of Lohiya, who said that indeed the reservation should be provided to backward classes of categories to deal with the non-social equality in India. Understood? So this is why the relevance of JP and Lohiya and their ideology remains relevant today. Now, in this regard, I've curated a question which is very similar to a PYQ that appeared in 2020. In 2020, question appeared on the similarities between Gandhi and Karl Marx. So similarly, now you have to identify the divergence between Gandhiism and Lohiya's ideology. So please let me know the correct answer. Sarang has already come up with the option D. Sir, does MDR have a fixed monthly rate or is deducted at every transaction? I told you, right? Deducted at every transaction. Some percentage of the transaction. That in cases of credit card, it is 2%. In cases of debit card or non-rupee based debit card, it is 0.9%. Yes, all of you are correct. Option D is the right answer. Opposition to caste-based inequality is where their ideas diverge. Gandhi says that although caste-based system is not an ideal system, however, it should be reformed from within. However, Dr. Lohiya said that first of all, you have to dismantle the caste system and then only you can ensure that there is an equality in the society, right? So the notes, now I will make them available on my Telegram channel. I'll meet you again tomorrow at 4 p.m. Until then, please do revise the notes and also Please make sure to revise all the notes in the regular manner. I'll see you again tomorrow. Please have a very good evening and a very good night.